Tonight, this is not politics. This is survival. Picture this: a good man, a careful man, a law-abiding man. He has one handgun. He keeps it at home. Same place for years. Top shelf, bedroom closet, hidden from sight, out of the way. He thinks that is enough. He thinks hidden means safe. He thinks home means private. He thinks nobody can punish him. Then family visits. A child comes over. 3 minutes later, everything changes. A noise, a question, a call, an officer at the door. Now, the issue is not ownership. The issue is storage. They did not tell him. The old rule in his head died. A life-altering mistake replaced it. He followed what used to feel safe, but safe feelings do not beat real statutes. And in state after state, hidden is not locked. High shelf is not locked. Nightstand is not locked. Closet is not locked. Your home is not a free zone. Your home is not a shield. And if a child, a banned person, or the wrong guest gets access, your private mistake can become a criminal case. That is the danger. That is the trap. And after a major 6-3 ruling in Bruen, many people heard only one message: gun rights got stronger. Then the court made something else clear in Rahimi, 8-1. Rights still have limits when real danger is involved. And in Bondi versus VanDerStok, 7-2, the court also said some gun kits and unfinished parts can still be treated like firearms under federal law. So if you think my house, my rules, stop right there. That sentence can ruin you. Oh yes, Supreme Court, oh yes. If you want this kind of warning before you need it, arm yourself with information. This channel tracks rights the second they change, not after arrest, not after the news cycle, before. So if you want this info in your corner before your family needs it, subscribe now. It takes 2 seconds. It could save you years. Now let's get to the briefing. Here is the legal collision. Two rights are smashing into each other. Your right to keep a firearm and the state's power to stop harm. That is the fight. And there is another collision too. Your privacy at home against their legal reason to search. Because once a child gets hurt, or a banned person gets your gun, or somebody uses your gun in public, the private home story can end fast. Very fast. Bruen said ordinary, law-abiding people cannot be forced to prove a special need just to carry a gun in public. That was a huge win for many gun owners. But Rahimi said the government can still disarm someone a court finds to be a credible threat. That means the Second Amendment is strong but not unlimited. Strong but not unlimited. Say that again. Strong but not unlimited. Oh yes, Supreme Court. So tonight I am giving you 7 laws, 7 traps, 7 ways a decent person can walk into disaster inside his own home, not because he was evil, because he was behind, because the law moved, because nobody explained it in plain English, so I will. Law number 1 is Massachusetts, and Massachusetts is brutal on this issue. In Massachusetts, the basic rule is simple. If the gun is not on you or under your control, it must be locked. Locked container or a locking device, properly engaged, not put away, not my kid cannot reach it, not company is not coming over, locked, that is the word, locked. And the penalties are not cute. For many firearms, violation can mean a big fine, jail, or both. If a person under 18 may access it, penalties can get much worse. Much worse. This is one of the clearest examples in America that your own home does not erase storage law. So if you live in Massachusetts, hear me clearly. Hidden is not locked. A drawer is not locked. A shelf is not locked. A closet is not locked. Locked means locked. Massachusetts legislature law number 2 is New York. New York's rule hits many people because it is tied to who lives with you. If you live with somebody under 18 or somebody you know is banned from having firearms, New York says you cannot leave that rifle, shotgun, or firearm out of your immediate control unless you first lock it in a proper safe storage container or use a gun lock. That matters. Because a lot of people hear, I own it legally. But New York is asking a different question. Who else is in that house? Who else is in that apartment? Who else can touch it? A teenager, a person under an extreme risk order, a A person with a felony record? If the answer is yes, New York expects real storage, not wishful storage. Real storage. And the law says first-degree failure to safely store can be a Class A misdemeanor. That is not a warning label. That is a criminal charge. And New York also extends this thinking to guns left inside vehicles. So the state is telling you this: if the gun leaves your hand, the lock better begin. New York Senate Law number 3 is Connecticut. Connecticut focuses hard on loaded firearms and minors. If you store a loaded gun on property you control, and you know or should know a minor under 16 is likely to get access without permission, the law says you must secure that firearm in a locked box, another secure container, a location a reasonable person would think is secure, or keep it close enough to retrieve quickly. That is a real duty, a real duty. And if you violate that duty, the consequences can be severe. Strict civil liability if harm follows, and a Class D felony with up to 5 years in prison, a fine up to $5,000, or both, unless the minor got the gun through unlawful entry. Read that again in your mind. A felony inside your own home, because the gun was loaded, because access was likely, because I thought it was okay, does not save you. This is why I keep repeating it. Good people get wrecked by old assumptions. They do. They really do. Connecticut General Assembly Law number 4 is Michigan. Michigan's law says if you leave a firearm unattended on property under your control and you know or should know a minor is or is likely to be present, you must do at least one of 2 things: store it in a locked box or container, or keep it unloaded and locked with a locking device. That is the baseline. Now hear the danger. In Michigan, criminal liability gets heavier if the minor actually gets the firearm and then takes it into public, waves it around carelessly, hurts somebody, seriously injures somebody, or causes death. The penalties can climb from a misdemeanor all the way to serious felonies, all the way up. In the worst case, up to 15 years. That is not small. That is not a paperwork issue. That is a destroyed life. And the wording matters, not just is present, is likely to be present. That means the law is not waiting for the child to already be standing there. The law can look at what you should have seen coming: a nephew visiting, a neighbor kid stopping by, your child's friend coming over. If that was likely, the lock should have already happened. Michigan Legislature Law number 5 is Colorado. Colorado says firearms must be responsibly and securely stored when not in use to stop access by unsupervised juveniles and other unauthorized users. And Colorado gets more specific. A person commits unlawful storage if he does not securely store the gun and he knows or should know that a juvenile can get access without permission, or that a resident of the home is not allowed to possess firearms under state or federal law. Think about that second part, not allowed to possess. That could mean the risk is not just a child. It could be an adult in your house, a roommate, a boyfriend, a relative, someone with a disqualifying order or record. If you know that risk is there, Colorado says the storage duty gets serious. And unlawful storage is a Class 2 misdemeanor. Again, not a lecture, a charge, a real charge. This is one reason I tell people not to think only about kids. Think about prohibited persons too. The law does. Colorado General Assembly Law number 6 is Washington. Washington's law is one of the clearest examples of what happens when safe storage and prohibited person rules collide. The rule says if you store or leave a firearm where you know or reasonably should know a prohibited person may gain access, and that person gets access and then causes injury, death, a discharge, intimidation in public, or uses it in a crime, you can be charged. That can be first degree, that can be second degree, that can mean felony risk, that can mean gross misdemeanor risk. Now notice what Washington is teaching here. The trigger is not just ownership. The trigger is access plus misuse. Access plus misuse. And the law defines prohibited person by state or federal law. So the circle can be much wider than people think. This is where many decent people get blindsided. They are not asking, can I legally own this gun? They already know that answer. The question they forgot is, who around me cannot legally touch it? That is the real danger zone. That is the overlooked question. Washington State Legislature Law Number 7 is California, and California is moving even further. California already had criminal storage rules if you keep a firearm on property under your control, where you know or should know a child is likely to get access, or a prohibited person is likely to get access, and then access leads to injury, great bodily injury, death, or the gun being carried off to certain public places. California's Attorney General overview makes clear there are first, second, and third-degree criminal storage offenses tied to those facts, and there is more. A legislative summary for SB 53 says that beginning January 1st, 2026, a person who possesses a firearm in a residence must keep it securely stored when it is not being carried or readily controlled by a lawful user. That is broader, much broader. That means the state is moving from bad result after child access toward a stronger default rule inside the home. The first two violations are treated as infractions. The third or later violation can become a misdemeanor. So if you live in California, the law is telling you something loud and clear. The old casual home storage culture is over. Over. If the gun is unattended, the state wants secure storage. California Attorney General California SB 53 summary. Now stop, breathe, look at the pattern. Massachusetts says lock it if it is not under your control. New York says lock it if the wrong person lives with you. Connecticut says a loaded gun plus likely child access can become a felony issue. Michigan says if a minor is likely to be there, secure it now. Colorado says juveniles and prohibited residents matter. Washington says prohibited person access plus misuse can hammer you. California says the home storage duty is getting broader and broader. So the pattern is not random. The pattern is the warning. And the warning is this: your gun rights may be real, but your storage duty may be growing. That is the collision. That is the collision people miss. Massachusetts Legislature, New York Senate, Connecticut General Assembly, Michigan Legislature, Colorado General Assembly, Washington State Legislature, California Attorney General, and now we hit the trap door. But here is where most people get it wrong. They hear one Supreme Court case. They hear one headline. They hear Second Amendment win. Then they stop listening. That is the mistake. Bruen is a shield. It is a shield against certain kinds of overreach. Bruen said the state cannot force ordinary people to prove some special need just to carry in public. That matters. It matters a lot. But that shield is not a magic pass. It does not erase storage laws. It does not erase child access laws. It does not erase prohibited person rules. It does not erase domestic violence restrictions for people found to be a credible threat. Rahimi proved that. 8-1. 8-1. The court said dangerous people can be temporarily disarmed when a court has found a credible threat. So if you act like every gun rule died after Bruen, you can accidentally throw away your own shield. You can do it with your mouth. You can do it with your storage. You can do it with your pride. And some people do all three. They say too much, they consent too fast, they store too loosely. Then they act shocked when the case arrives. Listen carefully, the right is the shield. Your behavior decides whether you keep holding it. The right is the shield. Your behavior decides whether you keep holding it. Oh yes, Supreme Court. And there is one more layer. A lot of people still think it is not even a finished gun. Be careful, very careful. In Bondi versus VanDerStok, the Supreme Court held that the federal gun law can reach some weapon parts kits and unfinished frames or receivers that can be readily converted into working firearms. That was 7-2. 7-2. So if your house has kits, parts, unfinished builds, and a storage setup built on the fantasy that parts are not guns, you need to update your thinking now. Tonight, not later. Now. Oh, yes. So what do you do? What do you do tonight? What do you do before the knock? What do you do before the accident? What do you do before the family visit? What do you do before your words bury you? Here is the protocol. Do not miss a step. Do not skip a step. And if you remember nothing else, remember this phrase: do not say yes. Do not say yes. Do not say yes. Step 1, know your state tonight, not next month. Tonight. Do not build your life on internet folklore. Do not trust old range talk. Do not trust what your cousin said in 2018. Look up your state. Read the rule. Ask one question first. What triggers the duty to lock? In some places, it is any unattended firearm. In some, it is a child. In some, it is a prohibited person. In some, it is both. In some, it changes if the gun is loaded. In some, it changes if somebody actually gets hurt. The detail matters. The detail is the whole game. And if you moved states, stop assuming your old habits moved safely with you. They may not have. They often do not. Massachusetts legislature, New York Senate, Michigan legislature. Step 2, lock every unattended firearm. This is the cleanest rule, the safest rule, the easiest rule to remember. If it is not on you, lock it. If it is not under your direct control, lock it. Do not play games with words. Do not say, I was only gone a minute. Do not say, it was upstairs. Do not say, nobody knew where it was. Lock it. Locked container, locked safe, proper locking device. Whatever your state accepts, use it. Because hidden is not locked. Furniture is not locked. A backpack is not locked. A purse on a chair is not locked. Your glove box may not count. Your closet shelf may not count. Locked means locked. Make that your house rule. No exceptions, no lazy nights, no tired nights, no just for now. Massachusetts legislature, New York Senate, step 3. If a child may be present, raise your standard. Do not wait for the child to sleep over. Do not wait for the child to touch the handle. Do not wait for the birthday party. If a child is likely to be present, act now. That word likely shows up for a reason. The law is asking what you should have seen coming. If your home ever has children in it, your storage standard should go up instantly. Use a real container. Use a real lock. Keep the gun unloaded if your state points that way. Keep the code private. Keep the key controlled. This is not paranoia. This is survival. Michigan says likely presence matters. Connecticut says likely child access matters. California says likely child access matters. This is the warning line across the country. Michigan Legislature, Connecticut, General Assembly, California Attorney General. Step 4, think about prohibited persons, not just children. This is where adults fail. They think only about kids. The law often thinks bigger. A prohibited person may be in your home, a felon, a person under a qualifying order, a person with a legal bar under state or federal law, a person in crisis, a person you know should not touch a gun. New York talks about people under certain orders and people barred by certain convictions. Colorado talks about residents ineligible to possess firearms. Washington talks broadly about prohibited persons under state or federal law. So ask the hard question. Who is in your house? Not who do you trust? Who is legally barred? That is the real question. And if that person is there, your storage cannot be casual. It must be controlled, completely controlled. New York Senate, Colorado General Assembly, Washington State Legislature. Step 5. Control the key, code, and access trail. A safe is not enough if everybody knows the code. A lock is not enough if the key hangs nearby. A cable is not enough if the cutter sits beside it. Real control means real control. Who knows the code? Who can reach the key? Who can open the box? Who can guess the backup number? If you had to explain your setup in court, would it sound careful or would it sound lazy? That is the test. Would it sound careful or lazy? And if you keep parts kits or unfinished builds, update that plan too. Bondi versus VanDerStok is your warning. Do not build your storage plan on denial. Do not say, it is only parts. That excuse is getting weaker, not stronger. Oh yes, step 6. If police show up, step outside if safe, close the door, and do not consent to a search. This step matters. It matters more than people think. If officers come to your home after a complaint, a scare, a child issue, a welfare call, or a domestic call, do not make the next mistake. Do not talk your way into trouble. Do not invite them in because you have nothing to hide. Do not try to impress them with cooperation. Do not say yes. Say this: Officer, I want to cooperate within the law. I do not consent to any search. I want a lawyer. Then stop. Stop. Silence is not guilt. Silence is protection. You can be polite, be calm, be respectful, but do not open doors you do not have to open. Do not say yes, because once you hand away your privacy, your bad storage setup may become the center of the case, and then your own mouth becomes Exhibit A. Do not say yes, do not say yes, do not say yes. Step 7. Use the magic words, then shut up. The magic words are simple. I do not consent to a search. I choose to remain silent. I want a lawyer. That is it. Not a speech, not a debate, not a history lesson, not I know my rights, not let me explain. No explaining, no storytelling, no guessing, no volunteer statements, because people bury themselves trying to sound innocent. They talk about where the gun was, who visited, who touched what, why it was loaded, why the lock was off, why the safe was open, why the child was there, why the roommate knew the code. That flood of words helps one side, not yours. Use the magic words, then stop talking. That one habit can save your case, maybe save your freedom, maybe save your family. Now let me say the hard part. Some of you are hearing this and thinking, this sounds extreme. No, what is extreme is losing years because you thought a nightstand was a safe. What is extreme is getting charged because you thought a top shelf was a lock. What is extreme is watching your own words help build the file against you. That is extreme. This protocol is not extreme. This protocol is late. Late for many people, too late for some. So do not make this emotional, make it mechanical, make it routine. Every unattended gun gets locked. Every child visit raises your standard. Every prohibited person risk gets treated as real. Every code stays private. Every police contact gets calm words. No consent, no rambling. Lawyer first, silence second. And if you want one simple sentence to put above your safe, make it this: hidden is not locked. Put that in your head. Put it in your house. Put it in your family rules, because that sentence can save you from the oldest mistake in the book. Let me give you a real-world frame. A lot of gun owners are decent people. A lot of them work hard. A lot of them truly care. They are not criminals. They are not trying to hurt anybody. But the law does not always care about your self-image. The law cares about the setup. The law cares about access. The law cares about what you knew, what you should have known, who was in the house, who could reach the gun, what happened next. That is why this matters. That is why tonight matters. And let me say this clearly for the people in the back. Bruen did not erase storage laws. Rahimi proved limits still exist for dangerous cases. Bondi proved home-built fantasies can still collide with federal gun law. And state storage laws are still very alive. Very alive. So if you are still using old habits, you are gambling. Gambling with your freedom, gambling with your finances, gambling with your family name, gambling with your future. Do not gamble. Do not gamble your life on bad storage. Do not gamble your rights on bad advice. Do not gamble your freedom on one lazy night. This is not about fear. This is about discipline. This is about staying ahead. This is about never giving the system an easy case. And that is the key. Never give them the easy case. A sloppy storage case is an easy case. A talking too much case is an easy case. A consent search is an easy case. Do not build the easy case against yourself. Now let's close this down the right way. If you own firearms, do one thing after this video ends. Walk your house tonight, not tomorrow, tonight. Check every room, check every drawer, check every closet, check every bag, check every vehicle, check every code, check every key. Ask yourself 3 questions. Can a child get this? Can a prohibited person get this? Would this setup sound careful in court? If any answer scares you, fix it now, not later. Now. Because the worst time to learn your state law is after the sirens. The worst time to learn your storage rule is after a child touches metal. The worst time to learn the magic words is after you already said yes. Do not be that person. Do not be the good man who got destroyed by old rules. Do not be the careful man who was only careful by yesterday's standard. Do not be the law-abiding owner who confused privacy with protection. Your rights matter. Your habits matter too. Your storage matters. Your words matter. Your silence matters. And if this briefing helped you, arm yourself with information and subscribe. Because rights do change. Rules do move. And the people who survive are usually the people who heard the warning first. Stay safe. Stay sharp. And remember, hidden is not locked. Do not say yes. Do not say yes. Do not say yes.